Welcome, everyone, to AJIL Explainers. I'm delighted to have our guest today, Jean Galbraith from the University of Pennsylvania Law School, who is also a member of the board and whose essay appears along with a number of other essays on Trump 2.0 in the October 2025 issue of the American Journal of International Law. So be sure to check out Jean's essay as well as the others. And Jean, welcome. Today's topic is, of course, about the U.S. strikes on Iran's nuclear facilities. And so, Jean, just give us a little bit of the factual background of what happened for those who sort of missed it amidst everything else that was happening in U.S. practice with respect to international law during this period.
Well, thank you, Monica and Ingrid. It's great to get to have this conversation with you. And I guess I said a big picture of high generality. The issue of when the U.S. president can lawfully conduct a military attack abroad. It's an incredibly important and challenging issue, both in international law and in U.S. constitutional law. And I will start with the facts because that's, as a law professor, where I like to start. And we have to go back to the spring, this spring, which feels a long time away now. Where there had been several months of unavailing negotiations between the United States and Iran over Iran's nuclear program, in which Iran was thought to be fairly close to a nuclear weapon. And then on June 13th, Israel launched major strikes against Iran, many of them targeted at Iran's nuclear program, at sites and at nuclear scientists. And Iran retaliated with missiles that were mostly intercepted, but did some damage. So the United States initially said, we are not involved. But then on June 22nd, it launched a targeted strike against Iranian nuclear facilities. And more specifically, military pilots flew without refueling from a military base in Missouri. And then in the early hours of June 22nd, they dropped these, quote, bunker buster bombs onto Iranian facilities, bombs that Israel doesn't have and that can penetrate very deep into the ground, which is where Iran was thought to be doing much of its nuclear work and storing its enriched uranium. And the U.S. also launched missiles at a third nuclear facility from a U.S. submarine that was in the region. Now, these bombs clearly did a lot of damage, and President Trump claimed that they totally obliterated Iran's nuclear program. But I think more sober and accurate reporting makes fairly clear that although this was a substantial setback, it did not do existential damage to the program. So just to finish up the factual narrative, the following day on June 22nd, Iran retaliated by firing missiles at a U.S. military base in Qatar. And I think it's fair to describe this attack as an expressive gesture rather than as a functional attempt to do damage, since Iran gave notice to Qatar and all the missiles were intercepted. And after that, we got a ceasefire of sorts between Israel, Iran, and the United States. But the underlying issues remain simmering, and I expect we will see the underlying issues back with us. So these strikes by the United States, they're significant acts. They directly targeted another nation, Iran, and they inflicted considerable damage. They're also the first overt attack that the United States has done against Iran on Iranian soil in a very long time, although there's, of course, a long history of other kinds of strife between the two countries. I think these strikes also give us a chance, maybe the obligation as international lawyers, to think about the legality of them and on what they tell us about the Trump administration's approach to international law and the use of force. And also the chance as U.S. lawyers to think about these same issues from the perspective of constitutional law.
Great, thank you, Jean. And so before we get into the legal questions that you've just teed up, could you perhaps also say a bit more about how unique or not unique this strike was as an action, both for the Trump administration and in the broader arc of U.S.-Iranian and U.S. use of force, U.S.-Iranian relations, and then U.S. use of force operations more generally?
Yeah, so as to the Trump administration, so far what we've seen have been a lot of threats of use of force in various ways coming out of President Trump. The most sort of eye-popping have been about Greenland and Panama. We've seen this strike against Iran, and most recently we've seen the bombing of these boats that the U.S. believes contains international drug traffickers in the Caribbean and on the Pacific too. And I should say, To your last question, that basically every U.S. presidential administration in my lifetime has used force abroad in ways that raise serious questions of international law. Now, to your context about the sort of question about the broader context of U.S.-Iran relations and the use of force, I mean, this is a long, long story, and what it sounds like is going to depend on who tells it. But as I see it, in recent decades, the United States has had sort of two main concerns about Iran. One's been about the nuclear program. One's been about Iran's role in the region, and especially its support of non-state actors like Hezbollah, the Houthis, Hamas, and then various Iraqi and Syrian militia groups. So on this regional issue, and especially since the Second Gulf War, we've seen considerable fighting at a sort of low level between the United States and Iran-backed actors over the years. We can find this in basically any recent U.S. administration. And on one occasion, back in 2020, during the first Trump administration, this did turn into direct conflict between the two countries. And that was when the United States conducted a direct military strike that was intended to kill, and did kill, Qasem Soleimani, the high-ranking Iranian military official, who was basically in charge of coordinating the proxy fighting against the United States. And that strike took place not on Iranian soil, but on Iraqi soil. He was traveling through Baghdad's airport at the time. And Iran retaliated with some strikes on a U.S. basis in Iraq that did some damage but took no lives. Now, on that first issue of nuclear concerns, the story's very different. And I think that reflects a kind of different quality of the issue internationally. While countries around the world have a lot of different perspectives about what goes on in the Middle East, there's historically been a lot more international consensus on not adding to the number of nuclear powers in the world generally, and on keeping Iran from being a nuclear power specifically. And that's a matter where Iran, as a non-nuclear signatory to the Nuclear Non-Proliferation Treaty, has international legal obligations at stake. So Israel is the country which, for obvious reasons, is the most concerned about this. It's long been taking forcible action, mostly covert, but sometimes overt, to try to prevent Iran from developing a nuclear program. But with, I guess, some covert exceptions, the approach by the United States has historically been to focus on diplomacy over force. And in particular, starting with the George W. Bush administration and really escalated in the Obama administration, we saw the United States work multilaterally to get a bunch of UN Security Council resolutions that imposed various sanctions on Iran for nuclear noncompliance. And then near the end of the Obama administration, remember, we got the Joint Comprehensive Plan of Action, the JCPOA, or the Iran deal, in which Iran agreed to take a bunch of verifiable steps to scale back its nuclear program in exchange for a lifting of those Security Council sanctions. And very unfortunately, the first Trump administration, abandoned that deal. Iran resumed its nuclear program. It's in grave noncompliance with its international obligations. And indeed, just recently, all those UN security sanctions have now just been reimposed formally on Iran, following the use of something called the snapback mechanism. So all of this is to say that while the recent strikes by the Trump administration against Iran and their international legality can be talked about narrowly, and I think that's all we'll have time to do here, there's this much bigger landscape behind it, and these broader failures of international law and diplomacy.
Thank you, Jean. That's super helpful and interesting. Just to maybe you can get us started a little bit on the international law framework with which we consider whether the strike is consistent with Article 2.4 of the UN Charter and so on. And in that, does this background that you've described about nuclear weapons and a concern about a nuclear armed Iran, does that change whether this strike violates international law or not?
Yeah, so first let me say, I guess I feel, to the broader framework question, I'll do it. It feels a little like, telling you two about this, telling Steph Curry about like how to shoot a basket, right? But just to speak to it, as you say, our black letter law, it's the UN Charter, and, searing aftermath of World War II. We get Article 2.4 of the UN Charter, which prohibits the threat or use of force against the other nations by a nation and against their political integrity and their territorial sovereignty. And then we get those exceptions to it. And in the UN Charter, there's really only two. There's if the Security Council authorizes the use of force. And then we have Article 51, that nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack has occurred. And I guess this is core vision. The vision is peace unless there's powerful consensus, that's the Security Council, or if you've actually been attacked, that's the self-defense. They weren't interested in aggressive war. They didn't want a lot of pretextual chances to lead to war. They wanted peace. And this system has been kind of tottering along since then. So before we get to your kind of question about whether the nuclear context makes a difference, I feel like we have to talk a little bit about the system at large and the sort of ways in which it has not worked as anticipated, that in the ways that the framers of this United Nations thought. And really, the starting point, of course, is that the Security Council is not this functioning world policeman that was envisioned at the time of the UN Charter, but instead has mostly been this frozen body that very rarely is able to get together and authorize uses of forces that would be valuable. And this puts all kinds of pressures on the system. It might be a body. You might think the Security Council could deal with nuclear proliferation if it were a functioning body in a great way. And you can see places where it does some of that. We talked about those sanctions earlier that were against Iran. But it's also a place where the existence of the veto, and in a multipolar world where there's huge tensions between the powers that hold the veto, you are just not going to see a lot of action. And that in turn puts pressure on other spaces. It gives opportunities for bad actors to get away with more and to make broader claims about uses of self-defense that would be justified and to act in problematic circumstances. It also,
I think you're maybe being very euphemistic here.
Okay,
so,
Russia.
Just to put it, I mean,
Yep.
I think you've set up very generously the way we might think about uses of force by the United States in particular that might be seen as violating Article 2.4, right? You've laid the groundwork for the way the charter isn't functioning the way we might have hoped. But what you're really, but correct me, right? What you're really talking about is the United States and its allies historically using force in ways that violate Article 2.4 and then claiming some kind of self-defense in particular. And in terms of international law, is this strike then just kind of more of the same of that? I think I've given you plenty to hit around there, and I expect you to disagree with most of it, but I just wanted to put a little finer point on the conversation.
Yeah, so I guess I would say the U.S. and its allies at many times, also many other actors. I mean, the story of the Cold War is very heavily a story of two superpowers who can't agree on anything, and where the Security Council is obviously non-functional, carrying out proxy wars and uses of force. Then we get that sort of moment after the end of the Cold War where it looks like we're going to have a functioning Security Council again, and now we're back. And so there's a whole lot of illegality that has gone on through the whole system in ways that I think, some are appalling. Some I feel more normative sympathy to. Because of the failure of the system at large has put these pressures on the need to have maybe a more robust vision of self-defense and increasingly a kind of conversation around humanitarian intervention than you might have had if the Security Council was functioning. So I do feel it's important to get that into perspective. Now, this particular attack, as if you ask me about its sort of specific legality, I think you can look and you can see scholars who are debating this on either side. I myself, and I don't go this far in that CPUS article because I'm trying very hard to kind of keep my own voice out of it, but I would say this is an attack that's illegal as a matter of international law. And I say that although I have some sympathy with the specific policy objective of the United States, which is to keep Iran from getting a nuclear weapon. That seems like a valuable and important one. So I'm happy to go into the international law sort of accounts and why I don't think there's an international legal defense, or we can shift over and we can talk more about how you deal with those challenges, those situations where there's need for international action and it's not going to happen. But before I do that, I guess the one thing I would add is that while I'm sympathetic in the narrow moment, I'm not sympathetic in the broader moment. And that is because the first Trump administration took the United States out of this laboriously negotiated multilateral joint comprehensive plan of action that was designed to accomplish with diplomacy rather than force, and with potentially a long-term, more of a path to decency and reconciliation, constraint on Iran's nuclear program. And I think we've seen a little bit of regret coming out of the second Trump administration on this fact that there isn't a deal to be had, and there isn't a deal to be had because the U.S. tore up the prior one.
So I think I sort of want to say yes, let's do both for the question. So perhaps as an outline for how we might continue, start by asking you to elaborate a little bit more on the self-defense claim. Because that is one thing that is noteworthy, I think, about this strike, for example, in contrast to some of the other U.S.-led operations or U.S. operations that have operated, let's say, in the space of Security Council inaction on issues that many, though not most, and certainly the majority only of U.S. allies thought required some action, even in the absence of Security Council authorization. So I'm thinking, for example, obviously of the Kosovo operation, of the strikes in 2017 and 18 against Syria for the use of chemical weapons, and of similar operations that sort of operate in this gray zone where the Security Council doesn't act. So self-defense, then how we think about this particular operation in light of some of the other operations that have been conducted under the charter where the Security Council did not act, and some claimed that reflected paralysis as opposed to actually the functional operation of the Security Council. And then third, we could maybe talk about the implications for of the term of terminating the JCPOA and what that means for multilateralism going forward and diplomacy on non-proliferation going forward. If that sounds good to you. So just to start, let me ask you what you make of the self-defense claim.
So after part of Article 51 is that you're supposed to submit a letter to the Security Council that says you've acted in self-defense. And the Trump administration did that. They did that 5 days after, which in Security Council kind of practice is really late. And the letter really, and this is, I think, consistent of how the Trump administration is approaching all of its use of force, and maybe its sort of general approach to law. More generally, that letter doesn't have much in the way of legal reasoning. It is an extremely, letter that's got a lot of factual statements, very emphatic factual statements, and then a conclusory claim, and doesn't do much in the way of legal work. But to the extent that there's justification, of course, it is self-defense. And particularly here, the U.S. is not actually arguing individual self-defense. They're relying on the collective self-defense of Israel. And the sort of basic theory, there's sort of two basic theories you can think about. One is it will be an existential threat to Israel if Iran gets a nuclear weapon. And therefore, Israel is entitled, as a matter of preemptive self-defense, to attack Iran and destroy its nuclear program. And the United States, as an ally of Israel in collective self-defense, is entitled to join that. And that is a theory that relies on a vision of self-defense that I think is concerning because it has the potential to basically eviscerate the concept of self-defense, because once you define the other party as your enemy, and even if they are your enemy, you're sort of taking on a right to conduct an attack. In domestic context, we don't think that just because somebody is your enemy, you're entitled to go ahead and kill them in self-defense. You need to wait until there is something that's imminent enough that self-defense is appropriate. And in international law, it's the same kind of theory. Really, to use self-defense prior to an armed attack, what's going on the other side has to be imminent. And in this case, I think the best reporting is that Iran is still some distance, not a long distance, some distance from a nuclear weapon. And there's the further question that a nuclear Iran doesn't automatically translate to a strike on Israel, just as a nuclear North Korea doesn't automatically translate to a strike on South Korea. It does radically, and to me painfully, reshift the balance of power there. It raises the stakes and it's very scary. But it is not sufficient under international law, I think, as most international legal scholars would see it, to justify self-defense. And then the other argument that's sort of seen in the scholarship is that Israel and Iran have effectively been engaged in an armed conflict for some time because of the role that Iranian proxies are playing in attacking Israel, because there have been over time some direct strikes against this. And Israel's strikes of June 13th and the US response is a piece of that, broader conflict. And well, I think that's a sort of more interesting and close legal question. I don't actually think it's particularly close, in that even if Israel and Iran are in a conflict, this is what Israel did on June 13th is a major escalation in terms of location, scale, and target on the sort of nuclear side rather than on the conventional military or proxy size, in a way that goes against the purpose and language of the UN Charter, which is designed not to sort of encourage escalation, but to encourage tamping down. But there's some very good debates of the scholars about that on the Just Security blog and the AJIL Talk blog that I think are useful to read on both sides on that point. So that's, I think, where I land on the legality.
Would you just say a little bit about how you evaluate the Trump administration's self-defense justification in the context, let's say, particularly President Obama, uses of force? So, I mean, don't we have a long history of controversial uses of force in self-defense by the United States? And is there anything new here? I mean, I guess that's what I'm trying to get at, or is this just consistent with a long series of uses of self-defense by the United States under questionable circumstances?
So I think it is. The answer is, to me, it is consistent. The things that are new here are matters not of sort of kind, but of degree, and they are sort of the attack on a state, right, Iran, in the context of a nuclear program. A lot of what you've seen since 9/11 and so forth has been a kind of conversation around non-state actors and uses of force against non-state actors, and more you see that the kind of thinking and ease of that come over into the space of state actors, but not in a way that is, to me, unprecedented as I look back at US history. The other thing that's, the other two things I guess I would say that are distinctive about that is some of the Obama actions you can look at, and there's no colorable claim to self-defense at all. Here, the possible justification, I don't think it's very persuasive, but it is self-defense. You see some of the actions around humanitarian intervention, for example, which is not a space that the Trump administration seems interested in. So that would be one point. And then I guess the other thing that I would say here is that the choice between use of force and diplomacy, part of why these uses of forces against non-state actors have been going on is a sort of added lack of levers around diplomacy when you're dealing with actors that the US sort of views, and often correctly views, as terrorist groups. When you're dealing with states, you have more potential for diplomacy, and that again gets us back to that Iran deal and the sadness that I feel that it fell through.
I think, Jean, that this action is, you mentioned in your earlier remarks, the action against Soleimani during the first Trump administration, which, in the initial stages, I think that the government finally did offer, Article 51 report to the Security Council, but in the immediate aftermath of the strike, it was quite obvious that the US government did not have a consistent or even coherent theory, or was not willing to articulate one, if it did have such a theory, about why the Soleimani strike was or might have been lawful. Do you think that this action is like sort of analogous to the Soleimani strike, is in a weird way less significant, maybe more significant? Like, how do you place it relative to that strike? That strike for me was, for all the pushes that the United States has made on the use of force, that strike was for me an evident break in the direction of open disregard even for the frameworks and justifying forms of the jus ad bellum. And so I'm just wondering how you place this relative to that one.
So I think first I think I agree with you. There's a lot of parallels and similarities. I mean, you can get to the fine-grained differences. That one is sort of the justification is tied to the kind of proxy warfare that's going on and the role that Soleimani plays in that. This one is related really to this longer term but very significant concern around nuclear weapons. One is on Iraqi soil, which raises separate questions around the ability to do a strike without consent onto Iraqi soil. This one is on Iranian soil, which feels even more potentially alarming in some ways. I guess I would say I think I felt more worry that we were headed to a great sort of catastrophe from that particular strike, as it's what would happen from it. Whereas this strike led pretty quickly to a ceasefire, and that didn't feel surprising, while leaving the underlying issues completely unresolved in ways that could blow up deeply after. So that's one difference to me. Another difference that I say is significant, it's not on the international side, it's on the domestic side, is that strike came late in the Trump administration. There wasn't, it's 2020, there wasn't that much left of it. So you had another year to think about what a sort of disregard for international law would do. We're less than 1 year in. We've got another 3 years to think about a world in which I don't think the Trump administration sees international law as having any independent constraint other than to the extent that it mobilizes other actors to feel frustrated and put pressure on the administration. And even there, they may not feel a lot of constraint. And similarly within Congress, back then there was congressional pushback. There was congressional, sort of a majority of Congress felt that they wanted to signal that war with Iran was not what the U.S. was interested in. Here, by contrast, within the U.S. Congress, there was a resolution to, basically disapprove of the Trump administration's use of force against Iran, and that resolution didn't pass the Senate. So we see a different long-term landscape that, although the immediate incident to me is less dramatic in both its international legal break and in how it makes me feel about what it's immediately going to do, the longer-term risks feel as higher.
We've pushed you to look back and make a bunch of comparisons to prior administrations. Moving ahead from the timing of the strike on Iran, we've seen, I think what some people view as kind of a pivot to Latin America in terms of the use of force, and I think surprising to some people, we haven't seen the Trump administration engage beyond this strike, at least publicly, in the Middle East. But what we are seeing are these highly publicized strikes in the Caribbean and the Pacific on quote unquote narco terrorists. In terms of international law, and we'll get to the domestic side soon, but are these comparable? Do they present similar problems, or do you view them in a really different way?
Yeah, so to go back to Monica's claim that sort of for her the Soleimani strike was really a radical break, these ones to me are a very radical departure from how I think about international law. And I think flatly illegal. And also, I have zero sort of policy sympathy for this. I have some sympathy for the idea of addressing drug trafficking, but the mechanisms that is used here doesn't seem justifiable in any kind of policy way. So just to put a little bit more of a fine point on that, I guess if there are similarities, it's in both cases there's been a kind of cursory assertion of legality, but minimal interest by the Trump administration in actually justifying this legally. Both I think are illegal under international law, but this one much more of a dramatic and obvious and concerning level of illegality. Another similarity is Congress doesn't seem to care in either of these instances. You're not getting pushback from a majority. Now the differences are that here there has been nothing that looks to me like there's obviously no collective self-defense. The claim here would be individual self-defense. There's been no armed attack, no that can justify it, because drug trafficking isn't something that we think about as in drug traffickers in the United States. We don't think about them as a non-state actor that can trigger the law of war. There may be some states where they have a kind of role and control of territory and function enough like a rebel group that's different. But here, this is not a kind of armed group that is fighting for territory or otherwise out to conduct international terrorism. This is people who are engaged in crime. And crime that the United States is something that we fight, not using international humanitarian law, the law of war, but using human rights law, which comes with a set of rules and protections, because you can get people caught up in this who are not people that should be targeted with the use of force that you use in an armed conflict kind of setting. And here we have, there are other ways that the United States can deal with this besides blowing boats out of the water. There's a question about necessity and proportionality of the attack relative to the objective. And there's a just underlying question that even if you accept a kind of armed conflict framework, which I just find impossible to wrap my brain around, that we don't even know, are these people on the boats combatants? Like, what's the work that's been done to figure that out? Now domestically, I think there's also a really big difference between this and the Iran strike. And that is that now that we are 60 days into this, I think that these strikes are obviously illegal under the War Powers Resolution. And we can say more about that at any point.
A follow-up question about these boats before we move on to like the Security Council inaction and whatnot. Unlike, I think, I can sort of reverse rationalize, I think, a lot of what I see happening in the US government's actions internationally in the face of like these broader geopolitical changes that we see. So there's a certain way I can I can understand, I can understand the Iran strikes. I can understand a little like what is happening in the Middle East more generally, with what the US government's policy is in the Middle East more generally with respect to China and whatnot. These strikes against the drug boats, I don't have a well thought out understanding or rationality of how it fits into the broader like set of geopolitical interests that the Trump administration is trying to shape, other than the possibility that it is simply trying to establish and show its willingness to establish its dominance over anyone who dissents from its positions. Do you have a better thought out explanation for how these strikes fit into against the so-called drug boats fit into the government's broader sort of geopolitical calculations? And I
I
know that's always a hard thing to, I know, I understand all the reasons not to do that, but do you have one nevertheless?
I don't know that I have a great one. So here, let me offer the few things that come to mind, and but not with a lot of certainty. One is that there's a sort of spheres of influence geopolitical theory that is the Trump administration is manifesting, which really is kind of sort of resurgence of the Monroe Doctrine, or more likely the Roosevelt corollary, which is to say this is our space and we are the big bad guys. That big bad guys in it. So in that sense, it is establishing a kind of claim over regionalism that I think is consistent with the broader geopolitical strategy. And particularly, if you think about some of the there have been the conversations around Greenland, the stuff that's been said about Panama has been a little more aggressive, and that's that's consistent with this regional hegemony theory. I think there is. I don't think law is international law on the use of force has any kind of constraining power, as I said earlier, and this shows it pretty clearly. Unlike if I look back to say the Obama administrations, there are some things where I think that violated international law, but there may have been other things you didn't do because you were worried about international law, or you really struggled with that one. I see not a full constraint, but more constraining rules. And so once you get to a world of just policy, I think that the president and don't have an interest in international law, don't have an interest in human rights law, and do have an interest in looking tough, then I think shooting people who have very few people who are sympathetic to what they're doing, who are small people that can't fight back against the U.S. government, has a certain messaging that is in line with what the Trump administration may want to do.
This was Gene, this was a feature of the quote unquote war on terror as well, right? The Bush administration's ability to switch between a law enforcement paradigm and a use of force, international law use of force paradigm, basically at will, right? So we're going to use the criminal justice system when we want to prosecute terrorists when we could find them and bring them to the United States, and other times we will use Guantanamo and the enemy combatants. I mean, do you think that's a fair? Are the lines blurred in a similar way here? Because again, that is that's been a long-standing challenge for, I think, the use of force, especially in dealing with terrorism and now narco-terrorists.
So I think it gets to the kind of broader structural problem that when any nominal legal checks that exist are the limits on the ability of an interested party to reason how far their own precedent goes, those limits are pretty thin. So the Bush administration takes, a big jump on how it conceptualizes the law of war to get this sort of world of illegal combatants who we can treat either way, because sometimes they're not in uniform, so that means we can do some things, but then we can target them even when they're not in hostilities because they count as combatants. In a context where you're talking at core about actors who, the core original group there is Al-Qaeda committing acts of terror designed to kill U.S. civilians on U.S. soil. In the drug trafficking context, we are dealing with people whose motivations and means are very different here. Certainly not savory, but also not with those kind of features of the international terrorist organization that we made that first jump of the law of war to. And now you make this next jump. And then you can at some point ask yourself, well, what about any kind of criminal activity? any kind of criminal activity that contemplates any use of violence. Like, how can we make that jump too? And this is where having, non-interested legal decision makers, courts being a big one, able to step in is a significant matter. And in the Bush administration's war on terror, we saw a lot of the courts did a lot of work of slowing down and demanding, refinement of the legal reasoning and placing limits on what the administration did. In this context, because all this is taking place, on international waters, and you do not have, people who are landing in the United States with the sort of ability to access the U.S. courts, you're going to have a harder time finding those legal challenges, too. Although we may very well see them and may be seeing them.
Yeah, I think, another basis for legal challenges that were successful in the Bush administration or anytime you were taking an action against a U.S. citizen. So, some of those cases like Hamdi and so on were obviously generated by people who have due process rights. And it will be interesting to see if and when a vessel that's targeted winds up having someone on it who is a U.S. citizen, because for better or worse, I think that changes the calculus legally in the United States. So we'll see.
Although we can recall the Preston of Al-Awlaki, right? The U.S. citizen who the Obama administration targeted in Yemen, who was very involved in Al-Qaeda, the Arabian Peninsula, was a leader of that, and who the U.S. felt was a threat. And there was no path to court cases. There were efforts to have court cases, but
yes. No, I think you're right. I'm not suggesting that they're successful, but I mean, Al-Awlaki, I think in the end is entitled to due process. It's just he got the process that he was due, right? He has the standing to bring the claim, even if it is ultimately not successful as a anyway, we can leave Al-Awlaki. But I do think if we have a U.S. citizen who winds up being on one of these vessels that's targeted, I think for both political and legal reasons, we might have a somewhat different scenario, but perhaps you disagree.
I mean, I would like to disagree. But the courts have not, and Al-Awlaki didn't, his father was deemed not to have standing. But I would like that to be right. But we see that some of the rhetoric we have seen coming out of the Trump administration is suggestive to me that they are not super concerned about the rights of U.S. citizens. And we see that, for example, in some of the legal arguments that they made about once we've even wrongfully deported somebody to El Salvador, they shouldn't have any path into court. Some of that logic could have applied to, U.S. citizens. So we'll see. Or I hope we won't see. I hope that the international pressure, and you are seeing international pressure against the United States on these boat attacks, will tamper them down, but I don't know.
And can I get us back, if it's okay with you, Ingrid, unless you want to continue pursuing this line of inquiry, let's get us back to the strikes on Iran, on Iran's nuclear facilities, and to the sort of latent question that remains outstanding, which is, so one of the things that people sometimes say is, yeah, the structure of the UN Charter, given the infighting within the Security Council, or even putting aside the infighting within the Security Council, that the structure of the UN Charter simply is not up to task to deal with all of the contemporary threats that we face. And that's nowhere more true, the argument would go, than in a context involving weapons of mass destruction, especially where you have the possibility of a state acquiring nuclear weapons and fundamentally altering the strategic dynamic in a region that might then lead to the further proliferation, right? So this is one of the claims that is often made. And so I guess I'm just wondering what your thoughts are in response to the claim that nuclear weapons are different, chemical weapons are different. biological weapons are different, and that no matter what the black letter of the charter says, actions taken to deal with these weapons might be permissible, or might, even if not formally lawful, might nevertheless be condoned or acquiesced in, whereas comparable actions that don't involve efforts to sort of strip the adversary of these weapons would not. And I'm just wondering how you think about that, and even if you accept that theory, how it might apply or still might not apply to these particular strikes.
So I wrestle with this, Monica, and I know from reading your writings that you've done so even more than I have in this broader question about how to think about the use of force and the Security Council. So I guess I would say, first of all, that although the UN charter structure is creaky and has some flaws and doesn't work very well, it's better, much better to me than a world where we don't have it at all, where all the restraints are lifted. And that's a terrifying world. And so I think that as international lawyers, we have to be committed. We have to fight to preserve the core outlines of this structure, because the world will be in deep trouble if it goes. And that the path to sort of changes interpretation beyond the black letter text has to be a kind of story that is built around the way customary international law normally develops, which is buy-in by enough states and conversation, which sometimes can be led by individual actions that then get, validated over time by other actions. It's a complex process. And that really, that's the conversation that's been going on in humanitarian intervention. Wherever we've landed on it, it's been the kind of the way the conversation has unfolded. And I agree with you that the case of weapons of mass destruction is an area that feels very compelling. It's also an area where the possibilities for misuse are extremely high, as the Second Gulf War reminds us frequently. So I guess I think to me, I am uncomfortable with decisions that are unilaterally made by one or two countries about that it's okay to blow through the restraints on the UN Charter because you're going after what you perceive as a grave threat on chemical weapons and on nuclear weapons. I think there is a path for the illegal but legitimate space that we saw in Kosovo as a kind of rationale here, but it would have to be one where there's a lot more consensus built around it. And as a strategic matter, I would say that if the Trump administration has nuclear nonproliferation as a core goal, then so much else of what it is doing right now seems very, to go back to your what's the grand strategy point, seems very in tension with that goal. So claims that we may resume nuclear testing, that's one. Yeah. A world in which our US traditional allies in Asia are looking at the United States and saying, hey, are they just going to walk away? We've been part of why we have never pursued nuclear weapons as a practical matter, is we've been counting on the United States to be there for us. And I think we may be seeing a path where we start to see nuclear South Korea, Japan, same thing in Europe, right? The sort of Poland's, the Germanys, and so forth. They have some doubts about the U.S. commitment to back this, structure of the core charter. So if nuclear nonproliferation really is the goal, there's a lot of things that the Trump administration should be doing differently generally. And while Iran may be the enemy today, nuclear weapons in the hands of many countries is just a long-term, risk for all of us.
We're close to the end of our time, Jean. Are there any, we didn't really turn to U.S. constitutional constraints on the use of force. I mean, is there anything you want to say about that? I mean, are there any constitutional constraints on the use of force that are operative? I mean, it's a conversation that could take up a book, or it's a conversation that could take up 60 or 90 seconds. I don't know if there's anything you think that's worth saying at this point in the webinar about US constitutional constraints, but here's your opportunity if
All
so.
right. I'll say, I guess, two things. First, I'll give a shout out to Michael Glennon's piece in this AJIL issue, which is talking about the ways in which, since despite Congress's efforts in the 1960s and 70s, U.S. presidents had just increasingly in practice taken over decision making on the use of force. So I'll say that. The other thing that I will say is that as a scholar who thinks about the separation of powers, how do you divide power and structure checks and balances, there are really eerie similarities between the UN Charter system and the domestic law of the US constitutional rules on use of force. And Kurt Bradley and I have written about this. In both, the kind of original sense is, hey, there's going to be this collective body that's going to make the decisions, other in really narrow contexts of self-defense. The Security Council on the international side, Congress is got the declare war power on the U.S. side. It's really just self-defense of United States and territories and armed forces that the president can act. And then over time, just as in the international side, self-defense is asserted in broader and broader situations, and other kind of concepts creep in too, partly in the wake of a collective action failure, partly because of unitary actors who want to get things done. So too, we see that exact same dynamic playing out on the U.S. side, where over time presidents have just gone ahead and done the thing more and more, and the more you do it, the less it looks like something that we should think about as illegal, and the more the existence of any kinds of checks go away. So that's where we are. Again, to me, the domestic legality of the Iran strikes is fully consistent, with the practice of the last 40 years, whatever you think of its ultimate constitutionality before that. By contrast, the Venezuelan boat strikes, now that we are more than 60 days in, there is a U.S. law, the War Powers Resolution, that says you can't conduct hostilities after more than 60 days unless Congress has authorized them. And as long as you define bombing a boat as a hostility, which the Trump administration does not, but which I think common sense should say yes, then the executive branch is in violation of a congressional law.
Jean, thank you so much for this conversation, which was broad and deep, and from which I learned a lot. I really appreciate hearing your insights on all of this, as I know Ingrid and our viewers did. So thank you so much for being here, and thanks to our viewers for being here. And please stay tuned on these channels for further webinars on Trump 2.0.